Pretty good.
Okay. How may we help you today?
You can stand 6 feet away for COVID. That's the first thing you guys can do.
First thing, why are you here?
Doesn't matter.
Yeah, you see that?
Doesn't matter. It's a legally protected activity. I'm legally allowed to be here.
You got a card? May I see your ID, please?
I don't answer questions.
Failure to identify can go no kind of jail. And all they ask you that you have to identify yourself.
15-5-30 is the ID statute in the state of Alabama.
You are at a facility right now that
Failure to identify is a arrestable offense. So please let me see your ID, please.
I don't carry ID.
you don't have a driver's license?
I do. I just don't carry it.
Is it in your vehicle?
It's possible.
That's your vehicle there, sir?
No.
It's not your vehicle?
No, sir, it ain't.
It's not?
How'd you get here?
That's not. Is that?
How did you get here?
None of that's legally
If it's not
required.
his vehicle, then we can tow it then.
Yeah.
It's in the vehicle.
Yeah, totally.
And he don't have an ID, so he can't drive.
Right, so he can't drive.
Alabama state law says you have to have an ID.
Welcome back, everybody. As many of you guys know, I'm a law enforcement trainer and instructor. I train and instruct military and law enforcement all across the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, investigations, etc. And here we have another, I mean, let's just call it what it is. It looks like another contempt by cop video. It's super unfortunate, but here you have a law-abiding citizen that is, or activist, or whatever you want to call this person, right? Exercising his constitutionally protected rights. So before we get started, let's just talk about what his constitutionally protected rights are. So let's just go from the beginning. First Amendment. It's here on your screen. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble and to petition the government for redress of grievances. Time and time again, this is codified in statute. This is codified. And so here we have somebody recording, and law enforcement does not like it. And from the sounds of it, we're somewhere in the South here. The next case law, again, Supreme Court has stated in Brown v. Texas, 1979, that law enforcement needs what's called RAS, reasonable articulable suspicion of a crime, in order to detain and compel someone to identify themselves. And then we have the flag burning statute, case law, Supreme Court case precedents of Texas v. Johnson, 1989, where the Supreme Court has held that flag burning constitutes symbolic speech that is protected by the First Amendment. The Supreme Court further held that freedom of speech protects actions that society may find very offensive, but society's outrage alone is not justification for the suppression of free speech. So, just because you have somebody who is offended by him by him recording in public, by him exercising his First Amendment right, just because you find him holding a camera to be outrageous, doesn't mean that you have a justification to suppress it. And this is just basic, right? Like, let's really talk about what we're talking about here. We have two law enforcement officers that are willing to arrest somebody because they find the fact that he has a cell phone that everybody has, right? So everybody has a cell phone these days. So let's just really talk about this. Like, let's dive into this, right? So here's a cell phone, right? So they are finding something that everybody has on them, right? So let's say, because when I'm wearing my suit, my cell phone goes in here. This is not a violation of law, but somehow this is a violation of law, right? They are going to arrest me for doing this because they find it so offensive. They find it so outrageous. That's literally what we're talking about, you know? And the idea that getting my ID is going to change any of the elements or requirements for anything is just mind-boggling. So, you know, it just goes to show, you know, some things are just, I can't explain it. You know, I'm not gonna try to explain it. I know a lot of times, a lot of you guys will ask me in the comment section below, well, why? Where does this training come from? I'll be honest with you, I don't know. I don't know. I know that from what I see in the academies, they don't even touch on constitutional law. I've never seen in any FTO manual where it says, yeah, go arrest somebody because they're holding a phone, a cell phone. I've never seen it. I don't know. I don't understand it. If you're confused, I am just as confused as you are. And again, I'm a certified FLETC instructor. I'm a certified CLEAT instructor. I hold police accreditations in different states. I just don't know. I don't know. I don't know what I don't know, guys. So I have no idea. I have no idea the why, but we see it time and time again. So again, you guys are smart. You guys know the case law. You guys know the Supreme Court case precedents on this stuff. And so the biggest thing is just, understanding that, again, in order to detain somebody, in order to compel ID, you need more than just this. You need reasonable and retrievable suspicion. So again, if you guys like this content, please like, share, subscribe. And most importantly, the conversation continues in the comment section below. Go down there, ask me a question, tell me what you think of this video. As always, guys, long live the Republic.